We're about to start session 2. We have Bob Bauer. He's a professor of practice and a distinguished scholar in residence at New York University School of Law and co-director of its Legislative and Regulatory Process Clinic. He served as the White House counsel to President Obama from 2009 to 2011, and in 2013, President Obama named him to be co-chair of the Presidential Commission on Election Administration. In 2021, President Biden named him to be co-chair of the Presidential Commission on the Supreme Court of the United States. And the other participant in the conversation is Ben Ginsberg. Ben is a distinguished visiting fellow at Stanford's Hoover Institution and a lecturer at Stanford Law School. He was also the co-chair of the Presidential Commission from 2013 to 2014. He's a nationally known election lawyer with 38 years of experience representing participants in the political process with clients including political parties, campaigns, candidates, members of Congress, and state legislators, governors, corporations, trade associations, PACs, vendors, donors, and individuals. Come on out. Yeah. And he's represented 4 of the last 6 Republican nominees. I've already introduced Bob and Ben, who are joining us, and Monica. I hope you don't mind I started introductions before you got out here. No problem. Okay. So that is Bob Bauer at this end of the table, Ben Ginsberg in the middle, and last but not least, who I've not yet introduced, the moderator is Atlanta's beloved Monica Pearson. A legend here, she's led a distinguished career in journalism at WSB TV in Atlanta as the anchor of Channel 2 Action News at 5, 6, and 11 o'clock. She's received over 28 Emmy Awards and other awards for her reporting and her close-up segments. She's recognized as a humanitarian who assists in charitable, nonprofit, and community causes. She'll be the moderator for today's session. And again, we'll go for about an hour until 1:30, and then there'll be a short break before we resume back where we were this morning. Monica, thank you so much.
Thank you for having me, and we will have time for questions at the end. So if you have cards, please write your questions on those cards. They will be collected. Well, the election of 2020 is gone, but is definitely not forgotten. It refuses to become history. Here in Georgia, the proof of the pudding is in the ads that we're now all seeing for candidates running in the May 24th primary election. In this morning's session, I learned that you learned about the many checks and balances that make it virtually impossible to steal a presidential election. A question lingers is, should we be worried about our electoral system? How are recent U.S. government actions bolstering or undermining the current electoral system? Here to offer some great answers are Ben Ginsberg, former counsel to the George W. Bush and Mitt Romney campaigns, and Bob Bauer, former White House counsel for President Barack Obama. Now, these 2 gentlemen have been known to disagree plenty over the years, but they do have a great deal of respect for each other, as I learned when I got to have lunch with them today. Ben and Bob both served as co-chairs of the bipartisan Presidential Commission on the Election Administration, and they are currently co-chairs of the Election Official Legal Defense Network. Guys, thank you both for joining us today. Now, since you both come from different political parties and have disagreed in the past, what brought you together for the Presidential Commission on Election Administration? Age before beauty.
So right.
I don't know if I like that too much.
It's one of the things we disagree on.
Yeah, one of the things we disagree on. Yes, it's true Ben and I disagree. As a matter of fact, I really feel today, I should say, working with Ben has been a pleasure. I think he is a extraordinary colleague. Over the years, I know most people in this room have heard very good things about Ben. And I also know that over the years, some of you have heard some not so good things about Ben. And I want to tell you that I was the source of all of that when I was younger and more partisan, and I want to apologize to Ben today. So anything that you hear about Ben now, just consider it good.
Hearing that from Bob actually enhanced my reputation.
In any event, I was young and I was a little zealous. In any event, Ben and I came together, we met in 1982 on the opposite side of a recount for a congressional campaign in Idaho. And it was a contested election. It was resolved under the Federal Contested Election Act in the House. And we got to know each other then, and over the years we were adversaries, but we became friendly adversaries. And then, much to Ben's credit, frankly, I had been general counsel to Obama's presidential campaign in 2012, and Ben had been general counsel to Mitt Romney's campaign. And yet in the immediate aftermath of that campaign, when President Obama began to focus on problems with election administration, he cited in his victory speech in 2012 the problem of long lines, but he also understood those lines connected to other dysfunctions in the electoral process, administrative dysfunctions. He decided he was going to set up a commission and wanted it to be bipartisan, and the invitation came to Ben to co-chair it with me. And in the immediate aftermath of an election, certainly I've been in elections where my candidate is lost. It's a disappointing and sometimes even worse experience than that. And Ben agreed to do it. And so we have worked closely together in that connection and in that background, and we're closely together now on the project that we're about to describe. But you asked me the question, and age has spoken, so now let me turn it over to Beauty.
Well, truth was it was part of the therapy after the losing campaign. But Bob made an essential point for what makes our country, which is people ought to have the ability to vote without barriers being put up. And, you know, both parties are in favor of that. And so there are disagreements over the kind of provisions you have to be sure the vote is secure, but all eligible voters should be able to vote without unnecessary barriers. And so the Presidential Commission became a chance to try and make some improvements in elections. And Bob and I had done an awful lot of elections over the years, and we often met on opposite sides of recounts. And one of the things you can say about recounts is that it is the time you kick open the hood and look at the machinery of our elections. And our elections are, as you heard this morning, administered by over 10,000 jurisdictions. A lot of the people who you see in the polling place are elderly people. There are probably 1 million volunteers in any one election. That is not a precision machine. And so this commission became an opportunity to sort of address problems that both political parties had seen with the elections in terms of trying to make recommendations to improve our elections. Now, one of the essential parts of, I think, why the commission worked was Bob and I were the only political hacks on the commission. We had 5 elections professionals on that commission and 3 people from private business, including the person who was in charge of Disney theme parks, because, well, if you're going to worry about long lines, you're going to have Disney on the panel. And that led to insights that I think we were able to provide in terms of best practices. I should, just a little aside that tells you something about me and Bob and that commission. We did get a private behind-the-scenes tour of Disney World, and we did get to go down in the tunnels. And if you ever want to see opposites attract, it was when we turned a corner deep in the caverns and saw Buzz Lightyear making out with Cruella DeVille. And honestly, that I think inspired us that, well, that can happen. You know, D's and R's can like work on ways to improve elections. So we owe Brian Britton a great debt of gratitude. But that brought us together to look at a number of best practices, and the election professionals who we got to meet in the course of that period. And many officials around the country were extremely generous with their time and their advice to us. And we learned a tremendous amount, which is really what led us to sort of come together for the Election Officials Defense Network.
And that's what we want to talk about. I mean, there have been laws passed in states that criminalize and target people who are officials, elections officials. And many of them, as you said, are volunteers, and they get paid little or nothing. As a matter of fact, many of you in this room may or may not know that a Fulton County, Georgia election official, Shay Moss, is receiving the John F. Kennedy Profile and Courage Award. She was falsely accused of rigging the election with absentee ballots stored in suitcases at State Farm Arena. Public video showed she did nothing wrong, and there was an investigation too, but still, she literally was terrorized to the point of where she had to hide, go into hiding with her family. Now, she had to get police protection, all for doing her job. Where and what are we going to do to help these workers? Because if they fear for their lives, they're not going to want to volunteer or to even serve in these positions. So what you do, how will this help them?
Same order? Okay. Just a brief bit of context for the answer, which is we see something radically different occurring, radically different from expectations after the presidential recount in Florida in 2000, when the country was so focused on breakdown in the electoral process, inadequate funding of elections, inadequate support for election officials. And the country seemed to be committed to professional election administration. And that ties into the report that Ben and I worked with other commissioners on in 2014 and delivered to President Obama. And the report expresses a commitment to professionalized election administration, best practices, as Ben said, and laws that are consistent and promote best practices and adequate funding. Now what we're seeing is a move toward partisan control of the electoral process, and the threats to election administrations that you're describing, the threats to election administrators, is a subset of that move toward controlling electoral systems through the partisan political process, particularly through state legislators, although in collaboration with executives as well, willing executives in the same political party. And this is a huge problem. So in a nutshell, I'll just lay out a couple of things about the Election Official Legal Defense Network that David and I co-chair. It is a 501c3. Its home is with the Center for Election Innovation and Research. David Becker is here, who is the founder, and he is the ED of our organization, the EOLDN, the Legal Defense Network, which Ben and I operate as co-chairs of. And it serves two purposes. Number one, to provide free legal services to election officials who are the subject of state legislative threats in any form whatsoever, whether it's personal or official, that would interfere with the impartial performance of their duties. And secondly, a civil society effort to have communities emphasize to voters outside the back and forth between political parties about the guardrails of democracy. I'll stop right there because there's more detail here, and let me turn it back to Ben.
Well, Bob is exactly right in what we hope to accomplish. In terms of the part of providing pro bono services for elections officials who need it, that really comes together in two pieces. The first is that we have an advisory committee made up of elections officials, several of whom are here, and we thank you for your help with that. That is designed to get the word out to elections officials who may be under some sort of harassment, that we will help them. And our message is directly, we have your backs. The muscle for this is in our recruitment of lawyers who will provide the pro bono services. We've been really overwhelmed by the outpouring from the legal community to help us. It's both solo practitioners and some of the country's largest law firms have put us as part of their pro bono service. We deeply hope that the number of lawyers we have far outpaces the number of elections officials who need us. But we are concerned about the number of elections officials who have contacted us so far with problems, far more than it should be, should ever be under any circumstances, and the level of stress that we see and anxiety and sort of just obstacles in doing their jobs is so far greater than what we saw in 2012 and 2013 as we were talking to so many officials.
So what is the solution when you are in a place where there may not be, in some small county, where there may not be a lawyer, or they have that contact with your organization. Because the larger cities, we'll all get it, we know it. But it's when you get to past the burbs to the country where there is not that help available.
It will be available. We have lawyers who can, already, we have hundreds of lawyers who have signed up. By the way, these are vetted attorneys. We have not had any major issues with vetting the attorneys, but the bottom line is we can put them forward as attorneys in good standing who can provide the necessary professional services. And I think it's fair to say, we won't name names, but one of the first calls we got was from a tiny little county, from a Republican, by the way, who was having trouble with the local Republican officialdom and party putting pressure on this particular official in ways that were consistent with her antagonist election denial theories, let's put it that way, basically looking to seize machinery and materials and so forth. And we were able, though the state officialdom higher up stepped in and helped, we were able to find a lawyer for that small county. So that's why we want to get the word out. We want to get the word out because if people go to that site and contact us, wherever they may be, we will find lawyers for them quickly, within 24 hours. Now, as Ben noted, we're pairing them with the lawyers, meaning they can, if they decide that they prefer another lawyer, then we'll find another lawyer for them. But the attorney-client relationship runs from the official to the lawyer, not to Ben and to me.
Gotcha.
We're available to counsel if some local counsel says, listen, there's a question of election law that I'd like to run by you. We're glad to do that. But we're trying to just match them up with lawyers who are best suited to doing the work that needs to be done on their behalf.
I'm curious, how many so far have you had since this group has been formed? How many people have called you and said, we need help?
Tough to put an actual number on it. I would say a couple dozen.
So far.
Have called. Yeah, I mean, look, as in any legal case, often the best representation is one that doesn't result in any sort of formal legal action. So that when we get a call and we pair them with a lawyer, our first advice is you can probably find a way to resolve this situation. I mean, in other words, sometimes a lawyer with a briefcase who's more than 50 miles away coming into a community sends a pretty clear message that there will be more pushback from the elections official that might otherwise occur. And you were also asking about what we can do for elections officials. The second part of our program that Bob mentioned, the civil society part, is really designed to go into the most contentious elections areas and to bring together leaders of the community, business, religion, civic associations, education, to meet with the elections official. And we want to be sure that the pillars of the community are across the political spectrum, because a great part of this problem is sort of bringing the community back together. And so we want to get elections officials together with those groups so that the elections officials can describe why, which you heard in the first panel this morning, that elections can't be stolen, that there are checks and balances and safeguards in the way we conduct our elections, so that there will be a group to reinforce the accuracy of the elections in communities made up of people across the political spectrum.
But that gets back to the question that I think you all started talking about, and that is, people think you can't have a bipartisan discussion about elections. That's why we're in the mess we're in now, that everyone thinks if the party in charge is setting the agenda, you can't trust them. How do we get our elections back to the place where we really believe we trust them?
It's very important, just because there have been disagreements across a wide range of election-related issues, to distinguish between disagreements that the parties have, say, over voter access rules. Now, I'm from a party that tends to take a very liberalized view of voter access, and so early voting no excuse absentee voting, all sorts of what I'll call, and by the way, what our commission referred to as opportunities for voters to participate in different ways in the process are very important to me as a Democrat. Having said that, there are disagreements about how those rules are crafted, and you saw those disagreements on display in the fights in Congress over H.R. 1 and the Freedom to Vote Act. That's one set of issues, and you're going to continue to see disagreement about those issues, no question about it. But what we're talking about is the core defense of democratic institutions, and that's something there shouldn't be any disagreement about. That is to say that we want professionals counting our votes that we can trust. We don't want it under partisan control. We resist election denialism, which is grounded in fantasy and political opportunism, and that has to be resisted. And I'll just finish my little peroration here by saying that's one of the reasons we want the civil society engagement in these communities. Communities who are used to listening to Democrats and Republicans squabble with each other have to hear from community leadership where legitimate partisan dispute ends and illegitimate partisan dispute begins. They have to call the balls and the strikes.
I agree exactly with what Bob said, with the slight exception, if I may, that I come from a party that's very concerned about the sanctity of elections. And there are provisions that go to reassure voters that their votes are being counted accurately that come into play in this. I mean, Brian Kemp and Brad Raffensperger here, Governor Doug Ducey in Arizona, all had very articulate statements after the 2020 election about specific provisions in their state laws that let them tell former President Trump that he was wrong, that the elections were properly counted and certified. And so what Bob talked about in sort of the first group of state laws go into that balance between different views of the party that gets played out in the rhetoric as fraud versus suppression. That's one set of issues. I totally agree with Bob that there have been some laws in some states that kind of get into the election subversion category that are quite dangerous. Taking the certification of a vote from the professionals and giving it to the pols, bad idea. For people to have faith in elections, got to have people who are perceived as not partisan counting the votes. Some states have passed laws that criminalize the activities of elections officials, and that's something that the Election Official Legal Defense Network is dedicated to stopping. And then there are also some laws that provide increased power to poll watchers, the weaponizing of poll watchers. That causes us some concern because what you don't want is over-caffeinated poll watchers taking liberties with kind of the sanctity of the polling place and people actually being able to physically count ballots. So it's important to keep those kind of different issues separated as you analyze the laws in the states.
Well, in preparing to interview you two today, I did a little research, and going back to the January 6th, the attack on the U.S. Capitol, it was planned to stop the counting of the electoral votes. What changes would you want to make to the Electoral Count Act of 1887? Now, ladies and gentlemen, I learned that oddly, in 1876, the presidential election between Rutherford Hayes and Samuel Tilden caused this to change, for this act to be brought into being in 1887. Several states submitted competing slates of electors because the winner, Hayes, won 47.9% of the popular vote, but Tilden won 50.9% of the popular vote. So that gets back to the Electoral Count Act of 1887. Obviously, it's time for it to be revised, maybe? And if so, how do you all think it should be revised? And is it something that can be done bipartisanly?
The answer to that is yes. Let me just begin by saying, of course, Tilden did get a majority of the vote, but he didn't get the presidency. He was cheated out of the presidency. The Republican won. I think Ben still feels really bad about that. And I'm happy to put
It was my first recount.
I'd like him on the record on that point, but I know he feels bad. It can be done on a bipartisan basis. There is a bipartisan effort in the Congress, at least in the Senate so far, that Republicans and Democrats alike who believe that changes need to take place to that statute. It created all sorts of uncertainty, most notoriously the uncertainty about the role of the vice president, when for the first time it was asserted that the Electoral Count Act gave the vice president, as the presiding officer of the Senate, the authority to engage essentially in his own substantive vote count, suspend the proceedings, send the results back because he suspected their veracity to the states. There was even some concern that he might actually receive, unofficially, if you will, slates from state legislatures or from state legislators around the country and put them before the Congress as alternatives to the ones that had been officially certified.
Sound familiar?
Yeah, so that was one concern that obviously arose in 2020 about this statute and the need for the statute to be amended. There are others having to do with the nature of objections that members of Congress can lodge against electoral vote slates and the thresholds required to sustain those objections. So there's a lot of work to be done here to tighten up our understanding of what the congressional procedures are. And I think Ben would agree there is a basis. Hopefully the moment won't pass. You know, the closer we get to the presidential election cycle underway, the more, I won't say unlikely because I want to be more optimistic than that, the harder it's going to be, I think, to work through some of these issues. But there is a path to doing it, and there are Democrats and Republicans working on it.
Yeah, I agree. It is sort of a robust bipartisan effort right now to deal with the Electoral Count Act. I mean, what happened on January 6th showed that there was ground for interpretation in the act. And I don't know of anyone who's actually gone through the pain of reading the words of the Electoral Count Act who would tell you it was a well-drafted or easy to understand provision. I don't know how many of you are watching The Gilded Age on television now, but they spoke different back then, and so it kind of makes sense to modernize a bill written in that era with that cadence and that language into something that's contemporary, just on the basis, no matter what. And there are provisions that are difficult, and Bob's right. I mean, there's consensus on many things right now. The role of the vice president should be constricted to basically the ceremonial one. The threshold for objections to slates and delegations is likely to be raised. I mean, I don't know if it's going to be to 20% or a third or half, but that's, you know, something to be negotiated out, but the principle is there. There are also some difficult and knotty issues to deal with. When is there an emergency so that you can actually let people vote after the election? There'll be some discussion about that. The greatest stumbling block is going to be on the role of the federal courts and whether there should be another federal cause of action. Right now, the whole process is set up as kind of, you've got states, and it isn't clear if it's state executives or state legislatures on the one hand. There's the role of Congress, and there's the role of the federal judiciary, and they each have their claim to it. So part of the new Electoral Count Act would have to include a resolution of who's the final arbiter of contested slates from the states. And those are some pretty difficult issues, but they are being conducted on the merits, because one of the great things about the Electoral Count Act, and why there is really more than a glimmer of hope that something will come about, is that neither party can figure out how to game the Electoral Count Act to their advantage. You don't know who's going to be the vice president. You don't know who's going to control the incoming Congress, so, you know, the Congress in 2025. So you can't really go in and figure out how your party's going to get an advantage. So, like, maybe clarity would be a jointly agreed goal of the parties, which is why I think there's hope.
I completely agree, and one more clarity and also some more consistency with our best constitutional understanding of the role these actors play. The idea that the vice president can decide the outcome of the presidential election, the idea even that a majority in the Congress can override the will of the public expressed in voting around the country just is anathema to any reasonable notion of democracy. So I think that combination of starting from first principles and achieving clarity could make a huge difference. And it would be really shameful if this wasn't addressed before the 2024 elections.
Well, campaign financing is another major concern, and there are campaign financial violations. The Federal Election Commission, many people say, needs help, it needs to be strengthened. What are the chances of that happening?
0.
Zero.
I mean, just to be honest about it.
Yeah, be honest.
That's because Ben is a defense lawyer and has immoderate confidence in his own abilities. But
I'm retired. I'm retired. No personal
that's
interest
true.
here.
That's true. We don't do that. We used to do that also.
used
We
to
used to
do
face
that a
each
lot.
other
It
in
used to be
campaign
an
finance
issue.
cases
Used to be
too.
an
That's
issue.
right. It's interesting. The campaign finance regulatory scheme we have now was a product of the 1970s post-Watergate reforms. And times have really changed in so many different ways. The assumptions on which the statute was enacted have really radically, the circumstances, the structure of politics behind the enactment of the statute have substantially changed. And so I have to say, I don't see a constituency for reform. And I'll give you an example. When in 2019 and 2020, when I was before Democratic audiences and the subject of campaign finance came up, and I wanted to be provocative, I would ask that audience, give me the number, the total dollar amount that you're prepared to live with, above which you would not go to defeat Donald Trump. And you could hear a pin drop. Right? Because whenever if there are major stakes in an election, then each party does not actually want to put down its weaponry, if you will. It wants to raise and spend whatever it can raise and spend for what they think are existential objectives. And so if each party in a polarized politics believes it's a zero-sum game and they need to fight to the death, whether it's the Republicans who are afraid of the Democrats or the Democrats who are afraid of the Republicans or Donald Trump in particular, whatever it may be, they're not really all that interested in discussing limits on campaign spending and a more rigorous enforcement machinery. But
And let me explain a little bit why I said zero.
Please.
The Federal Election Commission is not, it's a problem, but it's not the problem. The real problem is a system of which the Federal Election Commission plays a role. This system, remember, was designed, went into effect with the 1976 elections, as Bob noted, to sort of enshrine small dollar donors is the way to stop corruption in our society and to lessen the influence of big money. Today, with that system in place, more or less since 1976, the precise opposite is what we have today in our elections. Truth is, there's still a lot of small dollar fundraising going on. Small dollar fundraising messages are the most poisonous, vitriolic ones in our entire campaign finance system today because they raise the most money. In fact, because there is still a living, breathing First Amendment in this country, as Supreme Courts have noted since 1976, you can't stop all big money from coming in. So the loudest megaphone in any election campaign over the course of the campaign today are large dollar donors. And so the whole system just absolutely doesn't work. And you need to reconceptualize the whole thing. The position of small dollar donors is the bedrock of where the people who are in favor of the law see it as just wrong and flawed and not relevant today. But, and I'm going to sound like a Republican here, in the For the People Act, the Democrats doubled down on this system that one way or another, everyone, whether you're for more regulation or less regulation, agree doesn't work, without any effort to reconceptualize the way we ought to be dealing with money in politics. So in that current environment, unless anyone here thinks the Democrats are going to get a veto-proof majority in the Senate and Republicans aren't going to retake the House, the chance of the FEC, for whatever that's worth in this scheme, getting reformed is nil.
I don't disagree with the fact that, this is an old statute. It was operated, it was enacted, as I said, under radically different circumstances. In many respects, some parts of it have worked well. The disclosure provisions of the Federal Election Campaign Act have brought transparency to the federal campaign finance system that it didn't have prior to 71, 72, the first enactment of the Federal Election Campaign Act. But we are in a different world here, and I'll tell you, ideally, what would happen, and I don't think Ben and I agree on this, is that if we lived in a different politics, the answer would be more public resources to support our electoral activity. Right now, I'm more focused on getting money to election officials, frankly. If there are billions of dollars to be found, let's get our election process, the actual process of administering elections, in the most robust possible shape with modernized machinery and adequate staffing. But I think the idea that we're going to find something that both parties can agree to, that is a restricted financing system that involves the kinds of trade-offs that Ben was talking about, which kind of big money, which kind of small money, whatever, it does nothing but foment disagreement. It's hard to see how we will reach agreement about it.
Is there any way for an agreement to be reached on the John R. Lewis Voting Rights Act? What will it take?
You want me to take that one?
Of course.
So look, Republicans up until this time have been in favor of reauthorizing the Voting Rights Act. There has been agreement between the parties on election administration issues before. The Help America Vote Act, the National Voter Registration Act. The parties can agree on voting issues. I looked at the John Lewis Act and the For the People Act before it as it was a 900-page bill to begin with. It was a 500-page bill when the Joe Manchin version came out. It was a bill that started with some good intentions that got hijacked by the Democratic Wily political operatives in such a way that they were never going to get bipartisan support for it, which I think you really have to have if you're going to change voting laws at all. I mean, it really does need to be a bipartisan solution. To me, that bill read like one put together by every special interest group on the left who had their own particular provisions put in, and nobody with a pen could say, we got to take that out because that's going to bog down the whole bill and we'll never get support. And I was on panels with people from the Brennan Center, for example, who said, yeah, it's a big bill, but these are all important to people who are essential to our constituency. And of course, you get more support the more provisions you have in a bill like that, but you also have more opposition than you do. And there were a number of planks in there that was so partisan that it just kind of killed the notion that it would ever be adopted, I think, in the Senate.
Anything to add?
The only thing I would add to that, I'm not sure I characterize every provision in those bills as partisan. It would kind of depend on what you mean. I know there's always this concern that the majority, and there's a history of this in this country, the majority any one time in the Congress tends to approve of reforms that are at least not inconsistent with their own interests. But I think there are some reforms that are more ideologically driven and not necessarily partisan in nature. But setting that aside for a moment, I do think it is a shame that what has passed out of view was the revision of the pre-clearance regime to answer what happened in Shelby County. It got lost. It wasn't first up and didn't dominate the debate. As Ben said, there were so many other issues in play, and I regret that, and I don't immediately see the opportunity. I've not heard of Congress being in any position whatsoever with the slim majority in the Senate, and the midterm is almost upon us to return to this issue, so I wouldn't say I'm optimistic about it.
I would add that there, I think, have been attempts to add some of the provisions from the John Lewis Act to the Electoral Count Act. I think if those provisions are pushed and added, it will kill the Electoral Count Act reform also.
I hope that doesn't happen, because that is, whatever you think about the merits of these other proposals and some of them I happen to think are important, nonetheless, got to do what we can do. And if we can get bipartisan agreement on the Electoral Count Act and avoid a repeat of 2020, I think we're just duty-bound to try to do that.
Okay. We now have questions from the audience. Since the Presidential Commission on Election Administration report was published before the 2016 and 2020 elections, should the current presidential administration issue a new executive order for an updated report?
That's yours.
Are you ready to come back?
Yeah, sure.
Okay. Look, at any time that, President Biden would to decide to do that, I mean, of course, I'm sure there are items covered in that report that could be revisited fruitfully. Of course, there's so much work now being done in the democracy space. I don't know that is needed. Work like this center's work and other work of just, extraordinary philanthropic institutions committed to democracy, protection and revival and reinvigoration, however you want to put it. But obviously, I would hope that if he did it, he'd get Ben involved.
Does the same level of bipartisanship exist today to that of 2005 when the Carter-Baker Commission was formed? If not, what can we do to build that to work collectively and collaboratively to build trust in elections?
It's a really good question. I would say our politics is much more poisonous and our country as a whole far more polarized than it was in 2005 and even in 2012 and 13 while we were doing our report. Building back the trust is a really important question that we have. And like Bob and I know many of you, we spend a lot of time thinking about how to protect democracy. The figure that animates me the most in this, that I think is the toughest question, is that in December after the election, you had 30% of the population saying they did not believe in election results. And in the 17 months, 15 months since then, there has been every major media outlet, print, video, almost every media outlet that you probably read has called the big lie, and just pounded that in, that there is no truth to what was said about the election being stolen or the results rigged. Yet, after that media barrage, the 30% figure has only grown. And that's a scary, that to me is the scariest thing about all of this, because you cannot sustain a democracy with 30% of the people not believing in election results. And whatever is being done now to fight disinformation, it ain't working, folks. And so we better think of something else to be able to attack that problem. And I think the answer to the problem is not a federal answer, because that's proven to not work, but it is very much a community by community project. It's what we hope to do our small piece on in the civil society program. But it's really important to realize the mindset of the 30% of the people who don't believe in elections. And because I am a Republican, and because I do spend time talking to Trump voters and listen to other people's focus groups and read polls, the 30% believes as passionately that the election was stolen as all of you believe that that was the big lie. And that divide in the country, which we see in lots of different ways in our society today, is what really the problem is. And I think the way to attack it is on a community level, in some of the most contentious places, by actually getting the voices on both sides of the debate in the same room.
Next question. With tensions high and recruitment of secretaries of states and other officials by those who have spread a lot of disinformation, what happens when some of these people become elected officials in charge of elections, and then the disinformation is used as an excuse to sow more chaos and disrupt elections?
It is a serious problem. There are people who are committed to the big lie of 2020 who are looking to have supervisory authority over elections, to accede to these high positions. In the background of this is something that we can't conceivably do anything about in the near term. I think this is for our children and grandchildren to worry about. But we really ought not to have partisan officials with political ambitions of their own running elections anywhere in the country. I think it's a big mistake. There's other ways of building in mechanisms for democratic accountability. But someone who runs for Secretary of State on that kind of platform and is thinking one day of running for governor, thinking one day of running for Senate, maybe one day running for the presidency, is ultimately just vulnerable to incentives and disincentives that are extremely dangerous. However, I will say this, some of what they say they are prepared to do, can do, will do, is dangerous rhetoric and reprehensible and a reason to vote against them. That they think they can do it is self-delusion. It's just self-delusion. I mean, there are so many remedies that are available to stop people from the worst kind of abuse of power in the service of partisan interests. It's not good to have these people in office. And some of them, by the way, have no experience in election administration. So that's another reason not to be happy about their accession to these roles. But there's a lot of bluster and nonsense. The notion that I'm never I'm free-forming here. But you know, I'm never going to certify Democrats. Democrats always cheat. Well, try that. Best of luck in court on that one. But I'll stop right there.
A question, what about the independent state legislature theory, the thought that state legislatures can ignore popular vote results and appoint their own electors?
Well, buckle your seatbelts, because we are going to hear a fair amount about that in the near future. So, does everybody know what the independent state legislature doctrine is? Should I?
Please explain it.
There are provisions in the Constitution that give state legislatures power over the time, place, and manner of elections, and then some specific powers in Article 2 for the Electoral College. The way that has manifested itself to this date has been the state legislatures choose the manner of selecting electors by passing a law in every state that says we're going to listen to the popular vote. There is a pretty strong argument under the Constitution that if a state legislature wanted to say, forget the popular vote, we, the state legislatures, are going to name the electors, there'd probably be a majority on the Supreme Court to allow them to do that. But of course, in this day and age, a state legislature that decides to tell the people to go pound sand in the vote for president is not likely to be reelected themselves. So the interim argument is, can state legislatures step in to override the results of an election, which I don't think would stand up in court. I think the greater danger, which ties back into the Secretary of State issue, is what happens if a state in a presidential race fails to offer up a delegate, fails to certify the result because the Secretary of State, for partisan reasons, won't certify a delegate, or a big county decides it's not going to certify its votes, so there's not a complete count for a state. Could a state legislature then step in and name the electors? And that's the possibility if the candidates you mentioned get elected Secretary of State or to some of the county offices.
Yes, I mean, I agree that this is, I think Ben absolutely correctly stated, the constitutional authority of state legislatures before an election versus what they might do after an election to change the rules when they decide they didn't like the outcome. The latter, I think they can't do. I think that's not going to fly with this court under any reasonable interpretation of the Constitution. But you know, there are opportunities for mischief in the name of the independent state legislators doctrine. I think Ben alluded to them. So as he said, this is going to be, number one, a subject the Supreme Court is going to be pressed to say something about, and has been pressed already to say something about, and some justices have expressed a real interest in this topic. And it is something we're going to hear relied upon for potentially some very dubious behavior by political actors in the states.
And it's been raised in the redistricting
Yeah.
context, which is where it may actually come up.
Which is worse, 1,000 votes from people who shouldn't be voting? I wish we defined how shouldn't be voting was. or 1,000 legitimate voters being blocked from voting? I guess because we don't know,
You mean like 1,000
it says
people who are-
1,000, I'm just reading it, 1,000 votes from people who shouldn't be voting. Who shouldn't be voting?
Well, I mean, let's assume you have a birthday party for 12-year-olds and the entertainment is you go vote. And I think everybody agrees that that's not legal, right? I think our agreement should generally be that those who are eligible to vote should be able to vote, and those who are not eligible to vote should not vote. I don't think it's a question of which is worse. I think Ben said it very well recently. We have a system that requires some balance to be struck between accessibility and security. And we've got to get that balance right and get the parties to stop, kind of peel them away from each other's throats over that topic. But I don't know how to say which is worse in that case because we don't want either.
Right.
Fair enough. Why not place a tax on election campaign advertisings to fund the operation of the electoral system?
Could you repeat the question again? I'm sorry.
Why not place a tax on election campaign advertising? So the question is, shouldn't we tax election campaign advertising to help fund the operation of the electoral system?
I
You
would,
won't- you-
I would say that putting a tax on a First Amendment right is probably not a real good idea, and it's been rejected in other contexts historically.
I don't think it's going to pass muster constitutionally. I agree.
Okay. Why is it not a federal crime to threaten election officials, election workers, and politicians? Why is it not a federal crime to threaten election officials, election workers, and politicians?
Well, I think it probably is in most contexts now. The question is who's enforcing it and how it gets enforced. But there are laws on the books that could be used to prosecute people, if you can catch them, who harass election officials.
Yeah, and I think in the last round of revisions to federal legislation, there was some discussion of toughening up the penalties for harassment of election officials. I'm afraid I can't call to mind the specifics, but some view of maybe making that a little more muscular.
Is the dichotomy between integrity and access real? Can you have accessible elections with integrity?
Sure.
We do.
Expand.
Ask the election officials. I heard there are people here I recognize, others I haven't had the honor to meet, but I think Ben and I found as we traveled the country in 2013, or I guess that's right, it was in 2013, and submitted a report in 2014, we came to really admire the ability of election officials, operating obviously pursuant to state laws, but nonetheless to run elections where you could have a high degree of confidence in both the accuracy of the count and also the integrity of the count. I think we have that. Now, is there always an argument that somebody can make, and you hear it on the different sides of the political spectrum? On the Democratic side, more accessibility, as Ben said. On the Republican side, cautions about, sacrificing security. There's going to continue to be that argument about balance, but we have that kind of an election process in the United States, in most states that I'm aware of.
What does electioneering, the art of increasing your candidate's chances of winning, become suppression, which appears loosely defined? And they give an instance. For instance, the statistical frequency of blacks voting one party makes them not a target by race, but statistics. What does electioneering, the art of increasing your candidate's chances of winning, become suppression, which appears loosely defined?
I see. So I assume what we're talking about here is you're deliberately going out and utilizing various forms of speech to discourage voting. You're targeting community. It's not that you're taking direct action to prevent their access to the polls, but you're engaging suppressive activity by other means of discouraging turnout. Is that the question?
That's what I'm guessing it is.
Yeah.
Well, no, go ahead. No, really, you.
Yeah, exactly. Alphonse.
Well, you know,
Besson.
it's an interesting question in the sense that get out the vote groups on both, who both like Democrats and Republican candidates, do not target communities of the opposite party. Right? So if that's what the question is, then I'm not sure every group that does get out the vote isn't a little bit responsible for it. If you're a Democrat, you know certain shopping centers to go to where you're likely to register more people. If you're a Republican, you know certain places to go where you're likely to register people. And you're not going to go into the likely places of the opposite camp. And I think that's the story of get out the vote groups across the spectrum. You know, tax issues aside, that's kind of what politics is.
Well, we only have 2 minutes left, so I'm going to use this question to end our panel with. What do you think of as areas or issues of potential bipartisan agreement with regard to elections?
Well, I think we've touched on a bunch of them. First of all, the notion that every eligible voter should be able to vote is one where you get bipartisan agreement. There's some quibbling about the details in there. And the Electoral Count Act is, I think, a second one. And Bob, you may know of some others.
Well, but the only other thing I'd say is there ought to be agreement, and there have been times of agreement that our election system in the United States is dramatically under-resourced. And it's just outrageous. It's just absolutely outrageous. We heard about this in 2014, and it's still true in 2020. Now, you have to go state by state and look at different circumstances, I'm sure. But there ought to be an agreement that when voters go to the polls, and by the way, election officials told us when we were on our field trips around the country, that they respond to communities of voters who like to be treated appropriately, right? Our report said that election administrators have the goal of treating voters the same way our best businesses treat their best customers. So the machines should work. The lines should be manageable. There should be people present and trained and able to work those very long days and provide information and guidance when people have questions. How can it not be that that's a priority? But it is not an adequate priority either at the state or federal or local budgeting level. But I can't imagine how that's a partisan issue, because you're going to hear from people who are trying to vote, get their kids to school, or drop their kids off, go to school, go to the vote, and then get to work on time, who find out that nothing's working the way it's supposed to.
Well, gentlemen, thank you very much. A round of applause, please, for Bob Bauer and Ben Ginsberg.